Yes, Your Lordship. Should I beg to mention item 5? Item 5.
Why?
Senior counsel is out of station. He's not available.
In fact, I'm ready on the last occasion also, Your Lordship. On various occasions.
He's out of station, Your Lordship. She's coming back tomorrow.
Oh, State of Meghalaya.
State of Meghalaya, Your Lordship.
Let it come on Friday, Your Lordship.
Come after a week, Lordship. After a week, Lordship.
This is a little bit. Mr. Meldompio, counsel has sought for accommodation on behalf of Mr. Dr. Muzika, senior counsel, who is appearing on behalf of the State of Meghalaya on the ground of indisposition of the said senior counsel. Mr. Vijay Kanta, senior counsel, appearing for the petitioner, has no objection to the prayer made. As prayed for, this is matter to 1 week.
Obliged.
1 week? 1 week, Your Lordship.
Obliged.
Please, Your Lordship. Your Lordship, I beg to make a mention of item number 13, or item number 3.
3.
Item number 3, Your Lordship. I pray for 2 weeks' time.
Why?
Mr. P.U. Bin is unwell, Your Lordship.
It's not well, I was informed, Your Lordship. After 2 weeks.
On payment by the petitioner, this is matter after 2 weeks.
Obliged.
Obliged, Your Lordship.
Please, Your Lordship. I get to mention item number 4. Lordship, I just need a week's time. I just got the award the other day.
Oh, here for the appellant.
Appellant. Just a week's time.
On prayer made by Ms. Senior Counsel, appearing for the appellant, seeking accommodation. This is not being objected to by Mr. S. N. Larat G, appearing for the state respondent. That is adjourned. This is after 2 weeks.
Obliged.
Lordship, a date may be fixed if it's not inconvenient.
Yes, Mr. Sen. What?
Any date, my lords. Any date is convenient.
We can see you come like and you. Can you? 17th?
Lordship.
17th.
Yes, 17th.
Obliged, my lord.
This is matter
Obliged.
17th.
Daily list item number 1.
Lordships, may kindly have the next item, item 2. Both matters are similar, they're connected. I'll be arguing from the second one.
Matter has been heard.
My lord, I had started on the last occasion. Basically, the issue is very short, my lord, but the facts are quite lengthy. In view of the history, my lord, following this particular case. My lord, the petitioners before your lordships are, my lord, teachers in a deficit school, my lord, aided school.
Yes.
And they have been placed under indefinite suspension, my lord, with effect from 2014 till date.
Yes.
Without any proceedings, my lord.
Yes.
My lord, on the last occasion, when I had started the matter, my lord, there were certain annexures which were not legible, my lord. So I have supplied typed copies of those, my lord, to the court master.
Boni. Oh, these are the type copies.
So, my lord, I'll start with page 19, annexure 1. This is the appointment of the petitioner, my lord. This is legible, but I've also given a typed copy.
Okay.
So, my lord, in the middle of the page on the right side, this is dated 14th of February 1995. This is the appointment of the petitioner at serial number 1, Aquila Tumpuny,
Yes.
St. Mary's RCLP School, Nongluwai, my lord. This is West Khasi Hills.
The appointment was dated 14 to
1995, my lord.
yes.
Yes, update this now. She can jog this. Pursuant to that, my lord, at page 20, the petitioner joined a service, my lord. Typed copies at page 21, Annexure B 1. Annexure B, my lord. Annexure 2, page 21.
Yes.
Now, in the meantime, my lord,
Yes.
if your lordships kindly see the page 21 again, my lord. Joining report was received by the then my lord, secretary of the managing committee by the name of Francis Dakar, who is my lord, a private respondent in this petition, my lord, performer, my lord. Now, between this particular person, Francis Dakar, my lord, at page 22, your lordships will find this is a matter before the Guwahati High Court, my lord, which is civil rule number 68 bracket SH of 1995. So there was a dispute of the managing committee, my lord.
Yes.
So by this judgment, my lord, the dispute was the matter was disposed of. It's not relevant to our case, but just to show, my lord, that there was a dispute. And there was also a criminal case, my lord, which your lordships will find at page 27, Annexure 4. Between two parties, my lord. Page 27, my lord, Annexure 4. Page 28, your lordships will see the cause title. There were 9 appellants who say that they're members of the managing committee, my lord.
Page 29.
Page 28 is the cause title, my lord, of the appellants. Don't mix up. And versus at page 29, number 1, Francis Dakar, my lord. Okay. So there was a tussle between this particular Francis Dakar.
This is the appeal against the earlier order.
No, my lord, this is a criminal matter, my lord.
Criminal, but here says writ appeal.
Oh yes, my lord. Sorry, my lord.
Writ appeal 3309. Not legible.
Yes, my lord. It's a civil appeal against the. If your lordships come to page 30,
Yes.
the operative part of the order, dated 12th of May 1998. Second paragraph, my lord, this writ appeal is directed against the judgment and order dated 4/6/96 as passed in the by learned single judge and civil rule number 68. Same matter, my lord. So this is an appeal against the order of the single judge, my lord. And this appeal was dismissed. Appeal was dismissed. Therefore, my lord, this particular Francis Dakar succeeded in the appeal also.
Yes.
And at page 31, my lord, is an order passed in Criminal Revision 11 of 2005. So there was a my lord, criminal proceedings also amongst these parties, my lord.
Yes.
Now, my lord, at page 38, Annexure 7, I have also supplied a typed copy of that, my lord.
Page?
Page 38, Annexure 7. I have supplied a typed copy also, my lord. You kindly refer to the typed copy, page 38. So during 2007, my lord, the petitioner was sent for training. Your Lordships has the typed copy, page 38.
Page 38.
Page 38, my lord.
38 of the type copy.
Of the typed copy, my lord.
Order pursuant of. Okay.
Yes, ma'am. This is an order dated 27th of February 2007, where the petitioner was sent for training, my lord. It reads, my lord, in pursuance to letter dated so-and-so from the Director of Elementary and Mass Education, Meghalaya, Shillong, the LP school teachers are, as per list enclosed herewith, are hereby deputed to undergo 2-year training course during 2007 for different training indications in the statement. Deputed teachers are directed to report to the respective training centers immediately and not to leave the training halfway. Now, my lord, and the next page, serial number 3 is the petitioner, my lord.
Yes.
So, my lord, she was sent for training. Now, upon completion of the training, my lord,
Yes.
page 46, or page 40, my lord, 40. Page 40, annex to 8. So, this is a certificate, my lord, release of the petitioner, release certificate of the petitioner from the training, my lord. This is dated 31st of December 2008. After completion of the training, my lord, at page 41, the petitioner rejoined the school with the joining report. Page 42 is, my lord, the acceptance of the joining.
Yes.
And upon joining, my lord, upon joining the school, my lord, wherein the said Francis Dakar was the secretary, from where she had gone for training, she started her teaching. However, salary was not being released, my lord, at that point in time. Now, your lordships may kindly have page 45. The typed copy is at 46. This representation was written by her on 13th of May 2009 for release of salary. This is when the problem started, my lord. Dated page 45, dated 13th of May 2009. This was written by both the petitioners to the Deputy Inspector of School, Nongstan, US Khasi Hills. And the prayer was for release of salary, my lord. If I may read, my lord. With reference to the subject cited above, we the undersigned do hereby beg and pray your kind authority to release our salary. It is pertinent to mention herein that a dispute and conflict between the party of management of the school affected the school administration, particularly the teaching staff, who have been aggrieved by the non-payment of salary, which is not justified whatsoever. Therefore, we beg and pray that your kind authority to kindly release our salary due to be paid. Now, my lord, at page 47, annex 13, the contesting managing committee, my lord, issued us these letters, warning memos, stating thereby, my lord, that we have not joined the school, which otherwise, according to us, my lord, the school from which we went for training for 2 years, we have rejoined back that same school. So these are the warning memos, my lord, at page 47, 48. Now we continue to, my lord, perform our duties.
Do you file your joining report before whom?
My lord, to the private respondent, that is Francis Dakar. Joining report, my lord, we had submitted to the my lord, Deputy Inspector of Schools. Again, my lord, I'll take your lordships to page 45, typed copy at 46. Oh, this is the payment salary made. Joining report, your lordships will find at page 41. We had made the joining report to the Deputy Inspector of Schools. Now, my lord,
But why would you file your joining report before the Deputy Inspector? You're supposed to file it before the Managing Committee.
no, because we were sent for training, my lord. We were sent for training, and thereafter, your lordships will kindly see the acknowledgement at page 42.
Yes,
This is the order accepting the joining, my lord.
just a moment. Look at the contents of this order.
Yes, my lord.
It says you have bypassed the legal secretary managing committee of the school. She is therefore directed to submit her joining report to the secretary managing committee.
My lord.
Have you done so?
Lord, after this, there's nothing on record except for the representation made by us, my lord, which I had already read, your lordships, at page 46.
It means you have not complied with this order.
Lord, there's nothing in my file, my lord.
See, if you produce this order,
Yes, my lord.
you'll find that it was issued by the Deputy Inspector of School.
Yes, my lord.
So he is a relevant authority. So he has issued this letter, this direction to you, and copy to the Secretary Managing Committee, St. Mary's. So which means that you are supposed to file your joining report before this Secretary Managing Committee,
Yes,
St.
my lord.
Mary's LP School.
It appears so, my lord. I'll just take your lordships forward because I don't have an answer to that as of now.
Fine.
So what happened, my lord, thereafter? As the teacher of the school, my lord, at page 56, we submitted our general report, my lord, of 2010 of functioning of the school. And then, my lord, in 2012, in view of non-payment of salary, my lord, we approached the then Guwahati High Court, my lord. Lordships may kindly have page 65 and excerpt 23.
Yes.
So, my lord, this is writ petition of 2012, my lord. I'll just give your lordships the number. Writ petition 185, my lord.
Yes.
So this writ petition was filed by both by the petitioner, my lord,
Yes.
for payment of salary. And the order your lordships will find, this is writ petition number 184 and 185, my lord. Page number 79 and extra 24. So two connected writ petitions, my lord. Writ petition number 184 and 185. The present petitioner is in 185, my lord.
Yes.
Now, my lord, at page 80, your lordships will see the date of the judgment, my lord.
Yes.
3rd of March 2014.
Yes.
So, my lord, I will come back to this judgment. I will read the entire judgment. But before this date, my lord, 3rd of March 2014, I'll take your lordships now to page number 86, next to 25. This is before the judgment of the High Court.
Okay.
This is 13th of July 2013. So,
Yes.
this is prior to the judgment passed by the Honorable High Court. Now, this is a resolution, my lord, passed by the School Managing Committee.
Yes.
This is where the problem is, my lord. It reads, my lord, it is hereby resolved by the Managing Committee of so-and-so to initiate disciplinary proceedings against Srimati so-and-so for her unauthorized absence from duty since May 2008 till date. It is further resolved that Srimati so-and-so be placed under suspension pending the disciplinary proceedings with the approval of the SDEO, Nongstoin, West Khasi Hills. So the suspension came prior in time, and the approval your lordships will find at page 87, the next page, the next 26. This is dated 10th of January. This should have been 2014, my lord, because the previous page is 13 July 2013. This letter should have been 10th of January 2014, my lord. So it's a typographical error, but nevertheless it is before the judgment of the High Court. It reads, my lord, as recommended by the Managing Committee, dated so-and-so, the suspension of Srimati so-and-so from the school on account of a long and continuous absconding from school duties is hereby approved. So, petitioner was placed under suspension.
Just move on. Yes.
Now, my lord, pursuant to this approval of suspension, I'll take back your lordships to the judgment passed by the single judge, my lord. At page 79.
Page 79.
Yes, my lord. The date of the judgment, your lordships will find at page 80.
Excuse me.
Page 80, this is 3rd of March 2014, after the suspension.
Okay.
Now I'll take your lordships to the relevant paragraph at paragraph 6, page 82. Page 82, paragraph 6, if I may read, my lord, what the single judge had recorded.
Yes.
Para 6, it reads, my lord, it appears from the pleadings and also from the submissions of the learned counsel appearing for the parties that because of a dispute between two managing committees, the petitioner is not getting her salary. But from the record, it appears that the government has released the fund to the said school in the name of the petitioner. In support of this fact, the petitioner had also annexed the copies of the budget 2009-10 non-government, non-planned teachers and a budget of 2011-12 non-government, non-planned teachers in the writ petition. In these budgets, it is clear that the government had released the fund to the school for payment of salaries to the teachers. Para 7. The state respondents filed joint affidavit in opposition stating that there is a dispute regarding the management of the school between two managing committees. As a result, the salary of the petitioner had not been released by the managing committee. From the aforesaid facts, it appears that there is a dispute as to whether the petitioners had really rendered their service in the said school, inasmuch as the private respondent had also filed affidavit in opposition stating that the petitioners had not joined the said school after the management of the school had been taken over by the new managing committee. 8. From the facts, it is crystal clear that the fund had been released to the said school in the name of the petitioner. So, my lord, it was recorded that the funds were released in the name of the petitioner to the school. The employees are paid the salary for their service rendered by them only because of releasing of the fund for payment of salary to the particular teacher. The particular teacher is not supposed to get the salary if he did not discharge his duties as a teacher. It is also equally settled law that once the service of an employee is utilized by the authority is duty bound to pay the salary for the service rendered by the employee. Article 23 of the Constitution in India prohibits forced labor. In other words, the extracting service of the petitioner as teacher without salary would mean forced labor, which is prohibited by Article 23 of the Constitution of India. Number 9. Mr. So-and-so, appearing for the state respondent, fairly contended that the petitioner may get the salary if they really rendered this service. He further contended that in the given case, it is required to find out as to whether petitioners really rendered their services as teachers in the said school. The disputed question of fact is not decided in the writ proceedings. Number 10. Keeping in view the well-settled principles of law as discussed above, this writ petition is disposed of by directing the respondent, number 2, the director of schools, so-and-so, number 1, to conduct an inquiry. This is important, my lord. To conduct an inquiry and find out as to whether the petitioners had really rendered their service as teachers in the said school during the period for which they had alleged that they had not been paid their salaries. The petitioners had really rendered the services. The salaries should be released. Number 2, the whole exercise of conducting the inquiry should be completed within a period of 3 months from the date of receipt certified copy of the judgment, so and so. The respondent number 2, while conducting the inquiry, had to keep in mind that the period for which the petitioner in so and so is not getting his salary is with effect from January 2008 till date, and the petitioner in so and so is not getting his salary with effect from January 2009 till date. The petitioners are directed to furnish certified copy of the judgment along with so and so filed by the respondents as within a period of 1 week from today. Before parting with this writ petition, this court is making observation that while conducting the inquiry by the respondent number 2, opportunities should be available to the parties to put in their respective cases. With the above directions, observations, the 2 writ petitions are disposed of. So, a direction was given to the government to conduct an inquiry regarding the dispute. Now, that is with respect to the salary. So, at page 88, your lordships will find the inquiry report.
Yes.
So, till such time this inquiry report was submitted by the government regarding the legal and valid managing committee, no decision was taken by the government. It is only after directions of the court, this honorable court, that this inquiry report was submitted. I'll just read the relevant portions. I'll take your lordships to page 92. Para 3, my lord. Verifications of records and documents. Para 3, page 92, my lord.
Yes.
It reads, my lord, the records pertaining to the case which was submitted by the office of SDSEO, Nongstoin, to the director. By this time, the designation of Inspector of Schools was redesignated to SDSEO.
Yes.
So therefore, it says Office of SDSEO, Nongstoin, to the directorate in which the jurisdiction of the school falls, which is also scrutinized. The following are the details. A. That a dispute on the ownership and management of the school, that is St. Mary's RCLP School, was settled in favor of Roman Catholic by the Commissioner and Secretary to the Government of Meghalaya Education Department as per order issued on 30/4/2013. This is very important, my lord. The dispute was actually decided by the government only on 30th of April 2013. It is thereafter that the petitioners have been suspended.
Okay.
So this date is very important, my lord. Through this writ petition, my lord, I will not claim any salary before this date, my lord.
Yes.
So the dispute was resolved as late as 30th of April 2013, which is a very important date, and it is thereafter that the petitioners were suspended petitioners were recommended for suspension on 13th of July 2013 and accepted by the government on 10th of January 2014. So it is after this decision of the government deciding the dispute that we have been recommended for suspension and have been suspended, my lord. So this is from where my claim starts, my lord. It reads, my lord, further at bracket B, that all the parties involved were informed to submit their views and comments as per court order dated so and so, and the replies are here highlighted below. The secretary of the managing committee so and so. Straight away take your lordships to the finding. Bottom of the page, para 4.
Yes.
Para 4, findings, bracket A. As per court order dated 3rd of March 2014, para 10. The main issue required for conducting the inquiry is to find out whether the petitioners had really rendered their service in so and so school. During the period for which they have alleged that they have not been paid their salaries, the petitioner had really rendered their service, the salaries should be released. In view of the facts stated above, and in order to arrive at a
You're
fair...
reading?
my lord, page 92, bottom
Yes.
of the page, para 4, my lord, which is the findings. I'll read again, my lord. Findings, bracket A.
Okay.
As per court order dated 3rd of March 2014, para 10, the main issue required for conducting the inquiry is to find out as to whether the petitioners had really rendered their service in St. Mary's RCLP school during the period for which they had alleged that they had not been paid their salaries. The petitioners had really rendered their service, the salaries should be released. Next page, my lord. In view of the facts stated above, and in order to arrive at a fair conclusion, the following points are highlighted below. The standing procedure for any school to avail the benefit of grant and aid from the government, is that it should have a valid managing committee duly approved by the office concerned where the school is located. Number 2, the valid managing committee should ascertain that the teacher are attending the duties on all working days and have faithfully performed the duties at all times. The requirement of funds should be submitted to the office concerned for release of a salary along with the utilization certificate of the previous grant drawn by the school authority duly signed by the teachers concerned. Next paragraph, Lord. Remarks. It is observed that since there are two identical schools in the same name, that is St. Mary's RCLP Nonglawai A and B, and as verified during the spot inquiry on 19/9/2014, that both the teachers, Srimati so-and-so, have not rendered the service in the original school of St. Mary's RCLP Nonglawai A, where their post was originally sanctioned, and whereas they have left the school A to serve St. Mary's RCLP B, which neither have a valid managing committee approved by the competent authority nor recognized by the education department, the claim for release of the pending salary is unjustified. The supporting evidence, the attendance register statement of the teachers, both so and so, which speaks for itself. Conclusion. On the above facts narrated, it may be concluded that the claim of payment of salaries filed by so and so in writ petition 184 of 2012 with effect from January 2008 and Srimati so and so in writ petition number 185 of 2012 with effect from January 2009 do not have a valid ground and should not be entertained, as the service was rendered in another school where there are no sanctioned posts and had not been transferred from the school A, which is originally sanctioned, submitted by the director so and so. So on the basis of this report, my lord, we are not entitled. But from this report, again I'll take your lordship to page 92 at paragraph 3A.
Yes.
On verification of records, my lord, this date is very important at bracket A, my lord. that this dispute was settled by the government as late as 30th of April 2013. Now, upon this report, my lord, we may not be titled for the salary for the previous service rendered. But pursuant to this order, my lord, pursuant to the suspension, my lord, no proceedings have been initiated by the department till date, my lord. And we are in indefinite, my lord, suspension, my lord, without any reason. And neither have we been paid the subsistence allowance, which is the prayer in this writ petition. That, my lord, firstly, the continued suspension with effect from 2014 till date, my lord, is totally illegal. It defeats all principles of natural justice and my lord, service jurisprudence. And, my lord, to this effect, we during the wait, my lord, during suspension, we had also submitted a RTI application at page 98, my lord.
98.
Page 98. The application is at page 97 and the response is at page 98.
Yes.
So, my lord, as per the response, this is dated, my lord, RTI dated 30th of October 2019 at page 97, and the reply is 21st November 2019 at page 98, annexure 31.
Yes.
And, my lord, kindly have the answer at para 6, my lord, or para 5 onwards, my lord.
Yes.
It reads, teachers have been suspended by the managing committee of the school and approved by the SDSEO, Nongstoin. Copies enclosed. To the next questions, they say, my lord, teachers have not yet been terminated. That means we are still in service but under suspension. And at para 7, very blatantly they say that departmental inquiry against the teachers has been conducted.
Yes.
So, my lord, we are under suspension. We are not terminated, but DP is conducted, though there is no DP, my lord. Aggrieved by this, my lord, we made a representation at page 99. And thereafter, my lord, we have approached this. We made a representation at page 99 to revoke the suspension in view of the prolonged suspension without any disciplinary proceedings, my lord. At page 102 is the response, my lord.
Hundred and two,
annexure 33. This is communicated by the DSEO, my lord, and they have enclosed a letter which is my lord, issued by the director of school education, which is at page 103.
Yes.
So, by reading of these letters, these two letters, it doesn't make head or tail, my lord, regarding the suspension. It does not, because these are issued pursuant to my representation for revocation of suspension. If I read page 102, my lord, representation for revocation of suspension order and release of subsistence allowance. With reference to the subject cited above, I am enclosing herewith a copy of letter number so and so dated 6th of October 2020, letter number so and so dated 10th of August 2015, along with the file note from the DSEO, which is self-explanatory for your information. So what was enclosed is the letter, my lord, on the next page. This letter also, my lord, reads, representation for revocation of suspension order and release of subsistence allowance. With reference to the subject cited above, I am forwarding herewith a copy of letter under reference along with file note regarding writ petition, so and so, and so and so, and for necessary action. So, my lord, nothing was done. Nothing was done, my lord. So, by this writ petition, my lord, what I am claiming is, my lord, for setting aside the suspension order, my lord,
Yes.
and to pay subsistence allowance, my lord. Now, I am not pressing on the salary prior to the inquiry, my lord, in the previous. My lord, the schools, deficit schools and aided schools, my lord, they're governed by the State Act, my lord, which is called the Meghalaya School Education Act of 1981, my lord. If I might just hand over a copy, my lord. I copy. So, my lord, if your lordships kindly have this act, which is the Meghalaya School Education Act of 1981.
Yes.
In the definition, my lord, at section 3, it defines, my lord, what is aid or grant in aid.
Yes.
So, my lord, aid or grant in aid means any sum of money paid by the state government to any educational institution, my lord.
Yes. Section 3.
Section 3, subsection 1. It's not in dispute, but I'll just point out. Now, your lordships kindly have page 7, internal page 7, section 8. Provides for
Section 8.
Section 8 provides for aid to recognized school, my lord. I will not trouble your lordships reading this because it's not in dispute, my lord. Now, my lord, at section 9, my lord, provides for terms and conditions of service of employees of recognized private school. So, my lord, a private school which is recognized by the government and receiving aid, the terms and conditions are governed by section 9. Now, section 10, my lord.
Yes.
Section 10 provides for employees to be governed by code of conduct. Which reads, my lord, if I may read section 10. Every employee of a recognized school shall be governed by such code of conduct as may be prescribed, and the violation of any provisions of such code of conduct as may be prescribed on the violation, I don't know why it's, employee shall be liable to such disciplinary action as may be prescribed. So section 10 provides that as per rules, a teacher of a recognized school, my lord, will be liable for disciplinary action as may be prescribed, my lord. Now, my lord, rules have been framed by the state government, my lord, for conduct and discipline of teachers, my lord. Let me just hand over, my lord, under section 10.
No year, no nothing.
My lord?
The year and details not given.
No, my lord, because this
When
I
was
have
this?
got from the education code, my lord.
No,
If
when
your
was-
lordships call for the education code from the book from the library, my lord, it's available in the book, my lord. I don't have that book. It'll be there in the library, my lord.
This rule I don't think has been framed under this act. Under this act, lordship, I'm very sure that no rule has been framed under the Act of 1981.
That's why it has to be.
I'm very sure about that.
If your lordships call for the education code, or maybe, my lord, I'll go through it and come back tomorrow again, my lord, just to be sure on this point, because I'm almost concluding.
This is from that Assam rule, your lordship.
But was it adopted?
Adopted
Lordship,
by
I don't know whether this has been lordship. That is the book written by the then father Paul Pitai, your lordship.
education code is there, my lord. It'll be there in the education code.
Extracted from that.
So we can continue tomorrow, my lord.
Education code is the a compilation of all this.
Compilation, my lord, compilation.
But under
contains
this act,
the
your
act.
lordship, under this act, I'm very sure, your lordship, that no rule has been framed by the state government.
So he is very sure.
He's very sure. If that is the case, my lord, then principles of natural justice will follow, my lord.
No rule has been framed. my lord.
Because you see, you're banking on this, on the rules. Rules have not been complied with. If there are rules, they have to be complied with. If there are no rules,
Principles of natural justice. my lord. We can continue tomorrow, my lord. I'll just check on the, because previously, my lord, this matter was heard long time back, my lord. I did send my colleagues to the library, and that this is what they brought.
you should
for
have
me.
given the list of book here. We have the book here.
It's there in the library, my lord. I have not handed over the list of books.
Tomorrow, no?
We'll continue tomorrow, my lord. I won't take much more time, my lord. I'll just cite a few judgments and the rules, that's it. I want my library.
Mr. Philemon Nomri, counsel to the petitioner. However, hearing is not concluded and will continue tomorrow. List accordingly.
Apply, your lordship.
Deeply.
Item number 6.
Please, Lordship. Lordship, pursuant to your Lordship order, we are required to prepare an informal paper book. The same has been complied with, Lordship. Unfortunately, the respondent are not here. I'm yet to serve a copy on them, so they're not present today.
Mr. Learned Counsel for the appellant has submitted that the informal paper book, as far as this case is concerned, has been filed before this court. None appears for the respondent. As prayed for, this is matter to 2 weeks.
Obliged.